My name's Christina Smith. For those of you who may not know me personally, I'm going to conduct a sexual harassment and abusive conduct prevention training. I do this every year. It's everyone's favorite time of year, including myself. So we'll go ahead and get started. So the purpose of this training is to review the elements of discrimination, sexual harassment, and other forms of harassment. We're going to be discussing the remedies available to victims of harassment under both California and federal law, which is helpful to know both as employees and as employers. Consider strategies for preventing and responding to discrimination and harassment, and then looking at abusive workplace conduct, which can encompass many different things. So what is the effect of harassment in the workplace? There's, beyond just the illegalities of it. When you're looking at the functionality of a workplace, it can have huge ramifications. So you're looking at increased absences, low productivity, general low morale, interpersonal conflicts, and of course the legal ramifications. So this is just to say that the effect reaches beyond just the civil liability. So as I said, this is a required training. So California requires all non-supervisory employees to engage in 1 hour of training per year, and then supervisors must participate in a 2-hour training. So this particular training will go until noon with a break in the middle. All right, so what is harassment? Regulations define harassment as several different things. So it can be verbal harassment, it could be physical harassment, or it could be visual harassment. Verbal harassment, you're talking about the classic, epithets, derogatory comments or slurs, or repeated romantic overtures, sexual comments and jokes, or prying into one's personal affairs. Physical harassment is the unwanted touching, the rubbing up against someone, and then full-blown assault, and then physical interference with movement or work. This one, the physical interference sometimes can get a little bit confusing. The classic example that I've used is someone's trying to leave the room and another individual is blocking the doorway and refusing to get out of their way. That can be a physical harassment, even though there's no touching of another person, but there is this physical interference with the individual's ability to leave the room or to do something. Visual harassment, this is things that people can see, right? So cartoons, drawings, posters, gestures, facial expressions, sometimes leering, which is, facial expressions, staring, that kind of thing. All right, so first we're going to talk about the legal implications of harassment. So when we talk about liability, we're talking about two different kinds. We're talking about the harasser themselves, and then we're talking about the employer. And when are each of those individuals or entities liable for harassment? So the employer is going to be liable to a victim of harassment if the harasser is a supervisor, or if the harasser is a non-supervisory employee and the employer knew or should have known of the ongoing harassment. So the important thing to remember here, and we're going to go over this several times, is that the employer is always going to be liable for harassment that is done by a supervisor. Now, that is called strict liability. You'll hear that term several times, but that's that strict liability. No matter if the employer knew it or not, the employer could be completely oblivious that this supervisor is acting this certain way. Doesn't matter, it's a supervisor, the employer's liable. And that's different for a non-supervisory employee. At that point, the employer must have known or should have known that this was going on in order for liability to happen. And now I skipped that first bullet, but it's important. The harasser themselves, no matter if they're supervisor, employee, anyone, they're always going to be personally liable to the victim for that harassment. Every person in the workplace, whether you're a supervisor, subordinate, coworker, that is found liable for sexual harassment is personally liable, like I said, and they are responsible for damages caused by the unlawful harassment. And we'll get into damages later. And it also may rise to the level of a crime under the penal code rather than in the civil context, which is mostly what we're talking about today. So both federal and state law prohibit sexual harassment. There's a lot of overlap between the federal and state law, but there is some key differences that we're going to look at. So first, who's protected by the law, both by federal and California? And now if you look, California is on all of those categories: employees, applicants, contractors, volunteers, unpaid interns, essentially anybody that is in the building of your business is protected by these laws. That is not true under the federal law. Federal law only protects employees. But we're in California, so everybody in the building is protected under California. So the federal law at play here is Title VII of the the Civil Rights Act, which is a federal law. It makes it unlawful for an employer to discriminate against any individual with respect to their compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. So that those are the specific categories of protection under the federal Civil Rights Act. State law, California Constitution, first and foremost, protects against employment discrimination and harassment by both public and private employers on the basis of sex, race, creed, color, and national and ethnic origin. So that is what is specifically stated in the Constitution. But California goes one step further and has the California Fair Employment and Housing Act, commonly referred to as the FEHA. And this is a statute that is designed to prohibit sexual harassment, discrimination, and retaliation in employment. So through the FEHA, the state is able to even further expand the protections beyond federal and beyond the California Constitution. So the Fair Employment Housing Act specifically prohibits harassment and discrimination. Harassment is conduct outside the necessary job performance for personal gratification, meanness, bigotry, or any other personal motive. The motivation does not need to be motivated by sexual desire. That can sometimes come up when people say, well, I didn't mean it that way. Or, that was not my intent. Like, well, your intent really doesn't matter in this context. So this is extended protection. So the FEHA protects those independent contractors, the unpaid interns, volunteers, as well as employees and job applicants. So that's where that expansion that I was talking about comes from. The employer duty, this is a huge difference that I want to point out. The employers must take all reasonable steps necessary to prevent discrimination and harassment from occurring. Employers get hit with this very often. We'll talk about this when it comes to like investigations and things like that. But if an employer can't show that they've taken all the steps that they possibly could to stop this from happening, if they become aware of it, or to try to prevent it from happening, they will be liable. Just a note, the Fair Employment and Housing Department, that used to be their name a couple of years ago. They changed their name to the Civil Rights Department. But the Fair Employment and Housing Act, so the FEHA, is still referred to in this way. It's just being enforced now by the Civil Rights Department instead of the Fair Employment and Housing Department. Okay, so this is just kind of saying what we've talked about already, but in a little bit different way. So FEHA, this extended protection to all of these different people. It's important because it's California specific. The FEHA, again, all reasonable steps necessary to prevent discrimination. Okay, so Government Code 12940A prohibits discrimination based on an individual's status as a member of a protected class. So, there's many protected classes under the FEHA for purposes of discrimination. But it's important when we're dealing with these kinds of claims to look at, is the behavior that the employee is complaining of linked to a protected class? Are they being treated this way because of their membership in one of these protected classes? And that seems like a simple question, but it's not always that simple, because you have to be able to show that it's specifically, the treatment is specifically because you are a member in one of these classes. So I think, yeah, here we go. This is better. So there are 17 sort of recognized protected classes under the FEHA. I won't go through them all. Some of the more common ones we see, race, sex, sexual orientation, religion, age, and disability. Those are probably the most common that we see complaints of, but there are a total of 17. Okay, just want to make sure there's no questions so far. And if you do have a question, go ahead and put it in the Q&A. It may take me a minute to get there, but I will try to periodically look at that. All right, so discrimination refers to a bias in the exercise of personnel management authority on behalf of the employer. So, you're treating one type of person or one class of people differently than another class of people or another person. And that disparate treatment is and that's poorly worded, but the reason for the difference in treatment is linked to one of those protected classes. So, is the employee being treated differently and negatively because of their protected characteristics? So, my supervisor treats my coworker who's a man differently and treats me differently because I'm a woman, and I can show that I truly, truly believe, and I have evidence that it is because I'm a woman, not because he's better at his job than me. That's the connection that you need there. So this is the specific, what we call prima facie showing. So this is the minimum that a plaintiff or an employee needs to show in order to have a successful claim for discrimination. So 1, protective is a member of a protected class, any one of those 17. Plaintiff was qualified for the position sought or was competently performing in the position held, so satisfying legitimate expectations. And then plaintiff suffered an adverse employment action, whether that be termination, demotion, some sort of reprimand. And then there's a causal connection between that discrimination and the adverse employment action. And we're going to talk about what that means. But all 4 of those things need to be met in order to move forward with the claim in court. So we're going to, the answer is showing, which I didn't want, but that's okay. We're going to go through an example here. So a white male supervisor was deciding on a promotion. Supervisor told others that an African-American female employee was not interested in the position because of family commitments, which was not true. Supervisor promoted a less qualified white male employee. Plaintiff provided statistical evidence showing that the company had never promoted any African-American employees in their history, and further, that less qualified male employees regularly receive more promotions than qualified male employees, or female employees, excuse me. The question is, does female have a case for discrimination? And in this case, likely yes, on both sex and race bases, because they could show the correlation between that protected class, their membership in that protected class, and the fact that they didn't get this promotion. Now, here's a different example, similar but a little bit different. So a female applicant applied for a position in the neurology department at a university. 21 others applied for the position, and the applicant did not get the position. Applicant was told by the university that there were several applicants. Many were reputable in the field of neurology, competing for the job, and the competition for the position was intense. The position required experience managing high-level research programs. The applicant had recently earned her doctorate, but did not have this experience. Department hired a male for the position, coming from another university where he had a similar position. The applicant provided statistical evidence to show there were no females in the neurology department at the university. And then the question again is, can she succeed in a gender discrimination claim? Here, the answer would likely be no, because it could be shown that her not getting the position was based on qualifications and not her sex. So if this was an entry-level position, and she had either more experience or a better resume, and she showed that the department had not hired a male in some years, then the conversation would be different. But in this case, there was clear reasoning why the other applicant got it. It had nothing to do with the sex. So that's kind of an example of where sex would not be the basis. All right, so moving on to sexual harassment specifically. So what is sexual harassment? Sexual harassment is a form of discrimination based on sex and gender, which is unlawful under California and federal law. So it's really just bolstering this discrimination concept with it being very specific to sex and gender. And then there's additional rules when it comes to sexual harassment, discrimination based on sex and gender. So in California, sexual harassment includes harassment based on sex, which includes pregnancy, childbirth, or other related medical conditions that are specific to females, or not even females, specific to a certain gender, gender identity, gender expression, or sexual orientation. Okay. Again, liability. The individual harasser is always personally liable for the damages caused by their unlawful actions. Personal liability means that you could be, as a harasser, personally responsible for compensating the victim from their own personal assets, such as bank accounts, home, automobile, any assets that that individual has could be on the hook. And liability of the employer. Again, we went through this, but it's very important. An employer is always going to be strictly liable for the unlawful harassment of its supervisors. It's immaterial whether the employer was aware or not. And employers can be liable for harassment by non-supervisory employees if the employer knew or should have known about the harassing behavior and failed to take immediate and corrective action. So in what instance could an employer should have known? They're going to say, well, I didn't know. No one complained to me. I wasn't told anything. There were no claims filed. They didn't go to HR. Those would be examples of that they knew. But examples of when they should have known could be, a supervisor or an owner, or, the employer witnessed something or heard a rumor about something, or, became aware that there was, discontent among the employees and failed to investigate those reports, that kind of thing. So it's not overtly being told to them, but there are reasons that we could point to that say, hey, you should have known something was amiss here and you should have done something to, at the very least, investigate and see if there was something bigger going on. All right. Now this is the federal, so that was state. The liability of the employer for federal, the employer knew or should have known that the harassment was taking place and failed to do anything about it. And that's true for whether the harasser is a supervisor or just a non-supervisory employee. So that strict liability is not there for the federal law, which really doesn't matter in California. Again, that's more state by state on that. So what's a supervisor? Sometimes this can get a little bit confusing if you don't actually have a title that implies supervisory role. That doesn't necessarily mean that they're not a supervisor. So a person qualifies as a supervisor for purposes of the California Fair Employment Housing Act if they had the discretion and authority to any of these three areas, right? If they are able to hire, transfer, promote, assign, reward, discipline, or discharge other employees, or even if they don't have the actual authority to do that, they have this, they can effectively recommend any of these actions. So if they can recommend this to another supervisor or, a city manager, for example, and their recommendation holds weight, and can be shown to hold weight, then that could qualify as the supervisor under the FEHA. Grievances. So if this employee has the authority to act on grievances of other employees or to effectively recommend actions on grievances, that would qualify as supervisor under the FEHA. Or if that employee has the authority to direct the claimant's daily work activities. So, if you're a shift lead, for example, and you're handling the scheduling, you may not be considered a supervisor in the traditional term, but under the FEHA, you could be. So, what does that mean? Supervisors, not only are the employers going to be liable for everything illegal that you do in this case, but you as a supervisor are responsible to take action if sexual harassment is reported to you or if they witness sexual harassment take place. So because you qualify under one of these three areas, you now have a responsibility to report anything that either that you are told or that you witness. And I'm told that there are some questions here. Let me go to that real quick before I move on. Okay. Statute of limitations for reported harassment. Generally, it's going to be 3 years. Can we get a copy of the PowerPoint? Yes, we can provide. Oh, Mario already said, but yes, we can provide the presentation. Do all harassment reports, even verbal, required to be forwarded to HR? Generally, that's a good rule of thumb to have HR involved. Is there a requirement? Not necessarily. If you were to report something to, let's say, your immediate supervisor or the city manager, they would still be responsible for making sure something happens. I always recommend having HR involved, but sometimes that's not always that's not always practical. It's rare, but sometimes the complaints are concerning someone in HR, and so you may want to keep HR out of a certain situation. But generally, HR should be involved, but it's not required. I think we are good on questions for now. Keep them coming. Like I said, I can't see them when they pop up, but Mario's kind of moderating that for me. All right. So kind of everything we've been talking about so far on one slide. So the differences between the federal and the California. I won't go through it all, not all of it, because we've talked about most of it, but some differences. So the federal law applies only to employers that have 15 or more employees. Rather than we look at California, it doesn't matter how many employees you have, the FEHA covers all employers, even if you just have one person. Yeah, and then the independent contractors, volunteers, unpaid interns, not covered under federal, covered under California. We did talk about that. Okay, so let's get into kind of the nitty gritty of situations where sexual harassment is happening. So there's two main forms of sexual harassment in the workplace. There's the quid pro quo, and then the hostile work environment. Quid pro quo is what I would say is sort of the classic example of sexual harassment that you see, in social media, in movies, in TV shows. This is a demand for a sexual favor in exchange for employment benefits, or demanding sexual favors by threatening some sort of negative action. And we'll go through those, but that's sort of the classic thing. In the movie, you get the old boss that says, okay, well, if you sleep with me, I will get you a raise or a promotion. Classic, but probably less common that we see in the workplace today. Hostile work environment is much more common, and it's more of an analysis of an entire situation rather than one fell swoop moment in time. So in a hostile work environment, you're looking at whether the plaintiff was subjected to verbal, physical, or visual, I should say, conduct. That conduct was unwelcome, and the conduct was sufficiently severe or pervasive as to alter the conditions of the victim's employment and create an abusive working environment. We're going to talk about what that means ad nauseum, but that last bullet is always the crux of a case. It's usually easy to show some sort of conduct and that it was unwelcome, but in order to be successful, you need to show that conduct was sufficiently severe or pervasive. And that's where things tend to fall apart in the legal realm. Just a kind of a side note, a claim of sexual harassment can establish the outrageous behavior element of a cause of action for an intentional infliction of emotional distress. So a lot of times what we see with employees that claim sexual harassment, they also claim this intentional infliction of emotional distress, which is a separate civil claim, but it is fulfilled by this outrageous behavior element that can be established by the same conduct that would constitute a sexual harassment claim. Hope that makes sense. That was a little bit of word salad, but I think that explained that. All right. So quid pro quo. So simply put, a quid pro quo sexual harassment claim is when a supervisor relies on his or her apparent or actual authority to extort sexual favors from an employee. So this threat may be expressed or implied. So what I mean by that is it could be specifically said, hey, you do this, I will do this. Or it could be implied by actions rather than actually verbalizing it. So typical quid pro quo sexual harassment involves some form of sexual advance or proposition by a supervisor with an express or implied threat that if employee refuses, they will be terminated, demoted, lose other job-related benefits, or alternatively, the employee may be promised better treatment, such as promotion, transfer, raise, or favorable recommendation if the employee submits to the sexual advances. So just kind of putting that in more of a context. And I know it says supervisor, but it doesn't have to be supervisor, and we'll talk about that too. It can be anybody at the workplace can be doing this. All right. Quid pro quo examples. So, female employee was asked to lunch by her supervisor to discuss her yearly performance review and consideration for promotion. Employee expresses clear interest in the promotion. Supervisor suggests that he will put in a good word for her with the committee making the decision if she agreed to his sexual demands. This is going to be that classic express quid pro quo, absolutely all day long. That's what this is. Now, with the second example, it's a little bit different. Employee and supervisor began having sexual relations. Shortly after the relations began, employee is given a promotion with a higher salary. Employee informs supervisor that they will no longer be engaging in sexual relations with them. The employee is promptly demoted back to the previous position without any explanation. So here we have a correlation. We have this timing aspect, right? Right after the sexual relations stop, some sort of adverse employment action was done, meaning the demotion, but it was never said. There was no expression of this demand. This is the classic implied quid pro quo example. It can be implied by the fact that she got demoted right after the sexual relations ended, that it was tied to that. And then it becomes the responsibility of the employer to show that it was based on something else. All right. So remedies for sexual harassment. We have injunctive relief. So this is a court order requiring the employer to either stop some action or take some action. There's economic damages. This is the most common. Lost wages, medical expenses, job search expenses. If they went to see a therapist, or if they went to, they left work because they couldn't be there, so they lost wages, that kind of thing. And then the most, I'll say, common or kind of the big driver in these cases are non-economic damages. So that's this emotional distress, this loss of enjoyment of life, things that are hard to quantify go into this category of non-economic damages. And that's where you see these huge numbers coming out of these cases are always going to be in these this number 3 section. And then punitive damages as well. These are less common, but punitive damages are intended to punish. And so it's just sort of another award on top of everything else, saying, it was so egregious, you should be punished beyond what you're already paying. And that they do qualify for that. All right, so moving on to retaliation. Okay, retaliation is prohibited. It occurs when an employee engages in protected activity, is subject to an adverse employment action, and then a connection exists between the two. So, what is a protected activity? This is some examples, really, but a protected activity is refusing to obey an order that is discriminatory, filing an internal complaint regarding unlawful activity, testifying or cooperating with a state or federal agency, or other similar conduct. I will say the most common retaliation protected activities that we see is an internal complaint of some kind, whether that be a complaint to HR or to a supervisor of either another employee or of some other illegality that's going on. Whether you're saying, I think the finance department is laundering money. If you have an true belief, a reasonable belief that is happening, you can't just say that with no reasonable belief. But if you have a reasonable belief that's happening, and then something happens to you after you bring it to someone's attention, that's going to be a protected activity. It's an extreme example, but that is kind of what we're talking about, that kind of action. So what is an adverse employment action? An adverse treatment is something reasonably likely to impair a reasonable employee's job performance or prospects for advancement. This is distinguished from minor or relatively trivial actions that are likely to do no more than displease. So we see this reasonably likely or reasonable employee. This reasonableness standard is what it's called. It is across all of civil law. It's based upon what a normal person in this situation under the circumstances would either do or think. It's very subjective. It's supposed to be objective, but it ends up being very subjective, and that's where a lot of issues arise. But you'll see that standard a lot, this reasonable employee. So some examples of adverse treatment: verbal abuse, a denied promotion, denial of overtime, denial of benefits, intimidation, reduction in hours. It could be demotion. It could be a reprimand of some kind. All of those things would qualify as an adverse action. And now this timing element is very important. So the connection between the protected activity and the adverse employment action. So this connection is made up of two things. It's timing and employer knowledge. So timing, the protected activity. So let's just say this a complaint from the employee. Okay, just so it's easier. So this complaint, and we'll go with the demotion, and the demotion must be close in time that they are related. So the complaint filed against the boss and demoted the next day, not 6 months later. So it needs to be close in time enough to show that they are correlated. The other part is that the adverse actor, so in this example, the boss, must also know that the protected activity had taken place. So, if the boss didn't know that there was a complaint filed before the demotion took place, then there couldn't possibly be a connection between that complaint and the demotion. Now, the employer is going to have to show that they didn't know, but that piece is very important as well. So retaliation from coworkers. If a plaintiff can show that harassment by coworkers followed plaintiff's complaint about harassment and that the employer had actual or constructive knowledge of the coworker's retaliatory conduct and either participated in or encouraged the conduct or did nothing to end it, then the harassment may constitute an adverse employment action for which the employer could be liable under retaliation theory. A lot of words. Really what that means is if an employee can show that they're being retaliated against by coworkers and that their employer knows that that is occurring and is doing nothing to stop it or sometimes even encouraging it, then they can be liable under the retaliation theory as well, even though the employer isn't actually retaliating. Sort of like that, knows or should have known type of standard for harassment that we saw. Okay, so what is not considered an adverse employment action? This becomes relevant all the time. So things that are usually considered not adverse actions are counseling, general criticism, negative performance review, a lateral transfer, a requirement to learn a new skill, or other trivial employment actions. But, it could be shown that a series of subtle yet damaging injuries could constitute an adverse employment action. It doesn't have to be a swift blow like a demotion or termination. It can be a lot of little things that happen. We're talking about this as like maybe this, maybe that, and that's true of these kind of claims. It's always very fact specific, very, based on the circumstances of each case. It's very much a case by case basis. And so you know, there's no one size fits all method for these claims. Okay, hostile environment sexual harassment. So hostile environment sexual harassment may involve various forms of verbal, visual, and physical conduct of both sexual or non-sexual nature, which have the purpose or effect of creating a hostile or offensive working environment. So to state a prima facie case for hostile environment sexual harassment, under either the federal or state law, plaintiff must allege that there was unwelcome advances, conduct, or comments, that the harassment was based on sex, and the harassment was so severe or pervasive as to alter the conditions of the victim's employment and create an abusive working environment. We've seen that very similar just a few slides ago. A lot of this is overlapping. All right. So, hostile environment. So, whose conduct may create the hostile environment? It could be supervisors, it could be coworkers. Clearly, conduct from the supervisors in the form of sexual advances, offensive sexual comments, or hostile conduct may create a hostile environment for employees. A hostile working environment may also be created by sexual conduct or remarks from coworkers. And also, the victim need not be the intended recipient of the offensive conduct. So, this is very this is kind of a niche area, but it does happen. So, vulgar and offensive email between two male employees concerning female coworker could be evidence of harassment, even though she was not the intended recipient of the email. So, if two individuals are emailing back and forth about another employee, not intending for her to ever see it, but she ends up seeing it, that could be hostile environment as well, even though that conduct was not directed at her. All right. So hostile work environment, sexual harassment. 3 varieties. Conduct directed at the claimant, conduct directed at others, and then widespread sexual favoritism. We'll kind of go through different examples of the verbal. I think these are a little out of order, but that's okay. Verbal harassment related to sexual harassment would be foul or obscene language, derogatory comments, explicit discussions about sexual activities, and comments about people's physical attributes. Visual, we talked about leering, staring, making sexual gestures, displaying sexually explicit objects, pictures, cartoons, graffiti, posters, or sending graphic emails, text messages, or jokes. And then the physical, kissing, hugging, grabbing, impeding, or blocking movement, which we talked about, and just plain old assault. All right. Physical touching is defined. So, unwanted touching, a hostile environment sexual harassment claim may arise when there have been no outright sexual advances or propositions, but where plaintiff is subjected to unwanted touching. Example, supervisor or coworker intentionally and repeatedly rubbing up against plaintiff's body or touching them in an offensive manner. And generally, physical touching is always considered more offensive than mere words. And when I say more offensive, I mean really what we're talking about is the severe or pervasive standard. Physical touching is always going to be considered more severe or more pervasive than maybe some other examples of sexual harassment. All right, so the severe or pervasive, I told you we'd be talking about it a lot. It does not need to be both. So the victim does not need to show that it's both severe and pervasive. It just needs to be one or the other. Okay. So when you're looking at severe, I think we go over this in a little bit, but the severity you're looking at really, how often is this happening? How bad is this conduct? Whereas pervasive looks at, more at frequency. It looks at, how is this really affecting the workplace? Is it, I can't think of another example right now, but we're going to go through in a second. I always get questions about the difference, and really there's not a huge difference, but the law likes to make things more complicated than it needs to be. So psychological harm. So plaintiff does not need to prove the psychological injury to maintain the sexual harassment action. And the hostile work environment does not require a diagnosis of a specific medical issue. So you don't need to show, I now have anxiety, I now have depression. That is not a requirement. Okay, so you've seen this unreasonable interference with working environment in some of these prima facie elements that we've looked at. So it is generally a question of fact whether the harasser's conduct was severe or pervasive enough to alter the work environment. And when I say a question of fact, that means that it is a decision for a jury to make. So there's questions of fact and questions of law. Questions of fact go to a jury. Questions of law go to the judge. So isolated incidents, even if highly reprehensible, may be deemed insufficient as a matter of law. So hostile work environment considers all of these factors. So it considers the nature of the unwelcome acts or words, the frequency of the offensive acts, the total number of days over which all of the offensive conduct occurs, the severity of the conduct, whether the conduct is threatening, and the context in which it occurs. Now, these are factors, not elements. Elements are things that all need to be met. Factors are things that are all just considered and weighed together. These are factors. All right. So when we're dealing with hostile work environment, then adverse employment action is not required. So we talked about all those adverse employment actions, demotion or a reprimand, things like the termination. You don't need to have that in order to be successful in a claim for hostile work environment. Complainant does not have to have a tangible economic loss or any other employment action, adverse employment action. The crux of a harassment claim is that there's some sort of assault on the complainant's personal sense of dignity and well-being. And so that's sort of the overarching idea behind a harassment claim. So the more incidents that occur, the less, quote, severe they need to be to establish hostile environment. To be deemed pervasive, the incidence of misconduct must be sufficiently continuous. So it has to do with length of time and frequency. Again, the abusive conduct does not need to be both severe and pervasive. One or the other will do. So isolated trivial incidents. So these are all, this is from case law that we include here. The court in this case said occasional, isolated, sporadic, or trivial acts are usually not enough to alter the conditions of employment and create a hostile environment. But, however, there's always the however. In some cases, a single incident may support a hostile environment claim depending on its severity. I know it's, I'm kind of going back and forth, but that just shows how subjective this area of law really is. There is no black letter law in some of these things. So this is just kind of a graphic that goes through what we've already talked about, but it can be a little bit easier to see it like this. So sort of this balance, right? You're looking at frequency. Is it just annoying or uncomfortable? What's the severity of it? Is it threatening or humiliating? whether it's physically threatening or humiliating or a mere offensive utterance, whether it unreasonably interferes with an employee's work performance, but none of these single factors is required. Okay. Let me check. Okay, so I do have a question. Does the employee have to give a verbal warning to the person harassing them before filing a complaint? You love this answer, but it depends. If the action is sufficiently severe, no warning is necessary. Now, in situations where actions are minor, so for example, someone comes up behind you and touches your shoulder, that in and of itself probably not going to be shown to be harassment. But if they come up to you, touch your shoulder, and you tell them, "Excuse me, it really makes me uncomfortable. Please don't do that again," and they continue to do that, then you have, even though those are relatively minor instances, but because you gave them the warning before and they continue to do it, that bolsters your claim for harassment down the road. But if it's much more severe action that was taken at the outset, you don't necessarily need to warn them. I hope that answers your question, Raquel. All right, so ethnic slurs by supervisor versus coworker. These are just kind of, I'll go through a couple of classic examples that you see in the workplace that have been specifically ruled on by courts. So even a single act by a supervisor may be severe enough to alter the conditions of employment. Thus, when a supervisor makes a single racial slur, it exacerbates the severity of the remark and may create a hostile work environment. So what the court really says here is, because the supervisor was the one to make a slur, the very fact that it's coming from a supervisor heightens its severity when you're looking at the severity of the severe pervasive analysis. The very fact that it's coming from a supervisor heightens that severity. That's really what that says. Because you have a higher expectation for your supervisors, they're held to a higher standard, inevitably. So the court in 2003, which is quite a while ago, but it's still true today, is perhaps no single act can more quickly alter the conditions of employment and create an abusive working environment than the use of a racial epithet by a supervisor in the presence of his subordinates. So that's where that idea comes from that court ruling. Okay. Workplace-related conduct. So the sexual act or the offensive conduct does not need to be committed in the workplace to have consequences there. So after hours counts. The Christmas parties, the weekend events, anything like that is still considered, workplace even after hours. Normal interaction between sexes. So simple teasing and offhanded comments do not amount to discriminatory changes in the terms and conditions of employment. This comes from that case there. If I don't want to try to say that, but from the city of Boca Raton. This we see all the time. We get clients that just don't really don't like their boss. Their boss teases them sometimes and don't like their attitude, and that alone likely will not be discriminatory because it does not change the terms and conditions of employment. The sporadic use of abusive language, gender-related jokes, occasional teasing is not actionable harassment. That's the exact quote there. And then also a single or rare microaggression would not normally amount to actionable harassment either. So what's a microaggression? A microaggression is a statement, an action, or an incident of indirect, subtle, or unintentional discrimination against members of a marginalized group. that could be race, gender, etc. So they're commonplace indignities. So normal, brief, and commonplace daily verbal, behavioral, or environmental indignities that communicate hostile, derogatory, or negative attitudes. I put some examples. You're aggressive for someone so petite. That could be a marginalized group of, usually petite, you're talking to a woman, or something like, you speak English better than I expected. That kind of a backhanded microaggression there, right? Based on race. Pet names, very common. Being a woman myself, in the job that I have, you get that a lot. Sweetie, honey, darling, sweetheart. And what's specific to microaggressions is the intent there. A lot of times they really have no idea that it's offensive, and it's not intended to be offensive. A lot of it has to do with generational commonalities, and it's something that needs to just be pointed out. Another example would be asking a woman her age, then looking at her ring finger. That one happens all the time. Yeah, I'm sure you all can think of microaggressions that you walk away from the conversation thinking, what did that mean? Or, what do they mean by that? Those are microaggressions. And before I move on, generally microaggressions aren't going to be enough to reach to workplace harassment. But if it's something that you point out to them and you say, it really bothers me, can you please try to do that? And then they intentionally continue to do that, or to say that, then you may have enough to have a claim. And that's where that analysis of the severe pervasiveness comes into play. But one-offs of these types of things are generally not going to rise to the level. Abuse is not gender-based. So sexual harassment can occur between individuals of the same sex. That's settled law for a very long time, but sometimes that can be misconstrued. It's like, well, I can't discriminate against a woman because I'm a woman. That is absolutely not how the law works. Sexual motivation, explicitly the FEHA states that sexually harassing conduct does not need to be motivated by sexual desire. The harasser's actual motive is completely irrelevant, whether that be misogyny, personal vendetta, misguided humor, boredom, lack of social awareness, all irrelevant. All right, before I get to this example, I'm going to check one more time for questions. Okay. All right, so Chantel works in sales at a retail clothing store. Her boss, George, is a gay man. George often comments on Chantel's body and breast size. Comments make Chantel uncomfortable, and she has asked him to stop, but he does not. Is this sexual harassment? So George's conduct is harassing, regardless of sexual desire or motivation. It is a form of gender discrimination and can happen even if there's no sexual desire. So the fact that George is a gay man, it's what he's saying, not why he's saying. Another example, Warren is a supervisor of Jill. On 2 occasions, Warren pats Jill on the shoulder to congratulate Jill for a job well done. Warren also refers to Jill as sweetheart during these 2 occasions. Jill complains and files a claim with the DEF. Was Jill subjected to hostile work environment? No. Well, this was an actual case, and the court said no, not sufficiently severe or pervasive to alter the terms and conditions of her employment. Now, if Jill would have told Warren stop and he continued to do it, the conversation might be a little bit different. Which goes to Raquel's question. All right, so sexual harassment permeated plaintiff's workplace. So plaintiff must establish that sexually harassing conduct permeated her or his direct work environment. Male coworkers' daily use of bitch or slut and other crude language to refer to women. This was an actual case as well. Court said that the daily use of those words created a hostile work environment for the female worker. Co-workers' comments about female employees' buttocks and sexual relationships and crude gestures toward the female employee when her back was turned. The court said no, it did not create a work environment that was permeated with sexual harassment. And that one always surprises me, but I think the reason that that's important to look at that is something that, you know, may seem like it raised the level, and sometimes things seem like it wouldn't raise the level. You really don't know. It depends on the court. It depends on the jurisdiction you're in. It depends on the jury you get. It's really, really subjective and kind of a gray area. And so we'll talk about that. But it's always better to err on the side of caution on these things always, because you just never know what's gonna fly. All right. So plaintiffs aware of other harassment. Plaintiff generally must show that the harassment directed at others was in her or his immediate work environment and that they personally witnessed it. So there can be no hearsay. Plaintiff must present direct testimony that such harassment occurred by the victims or witnesses. Plaintiff cannot rely on hearsay or workplace gossip. So a hospital nurse claimed a staff doctor was harassing nurses in the operating room, but she did not work with him in that operating room. She would not be able to introduce evidence of his operating room conduct in support of sexual harassment claim unless she was also personally subjected to such conduct herself outside the operating room, which is a bit confusing. But so this nurse, could not just say, I heard that he treats people this way in the operating room. But she can say, he treats me like this outside the operating room. In addition to that, I've heard that he treats other people this way other places. But because she has also experienced something from this doctor, she can use that evidence. But without her own experience, she cannot. I think that's the best way to say that. I pretty much just said that, but on the other hand, one who has been personally subjected to sexual harassment may introduce evidence of harasser sexual misconduct toward others, of which she becomes aware during her employment, even if the other acts occurred outside of plaintiff's presence, but only if they themselves have also experienced something. All right, quick true or false. An individual employee may be personally liable for sexual harassment if they are the person causing the sexual harassment. I don't know if it, nope, okay. Say it to yourselves. That is true, always, always, always. Second, to prove hostile work environment, sexual harassment, the complaining party must show they were subjected to unwanted sexual attention that was both severe and pervasive. Look around. Say yes or no to yourself. That's false. Tricky one, but it's severe or pervasive. Remember, don't need both. And third, California law is broader than federal law in providing protection against sexual harassment. That is true always. All right. I thought we were coming up on it. All right. So this is the end of the supervisor portion. Excuse me, the non-supervisor portion. Supervisors stay on. We'll take a few minute break and come back. All right, so moving on with the supervisors. So what is your role as a supervisor in this context? So to ensure work gets done appropriately, timely, and according to workplace policies. Workplace missions and objectives are accomplished. Safe working environment, meaning no tolerance of sexual harassment, and appropriate response to complaints of harassment, and general good morale amongst the team, which is always tied to implementation of these things. So as a supervisor, you are legally required to say something when you see unacceptable behavior. And that's sort of what I was talking about before. If a supervisor witnesses something or is told something, they have a duty to do something about it if it's unacceptable. So 4 key behaviors for supervisors. Number 1, model respectful behavior. And then you must speak up when you see inappropriate behavior. You must take complaints seriously and have them investigated, and work with fellow supervisors or HR team so inappropriate behavior is dealt with. So hostile work environment. A little bit more on this. Some of this will be redundant, but some things will be somewhat new or said in a different way for supervisors. So objective hostility of a work environment include the frequency of discrimination or the offensive conduct, its severity, whether it's physically threatening or humiliating or a mere offensive utterance, and whether it unreasonably interferes with an employee's work performance. All right, so this reasonable victim standard, I mentioned it earlier, so it's very important. So conduct in the workplace that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. Repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, or epithets. Verbal or physical conduct that a reasonable employee would find threatening, intimidating, or humiliating. And normally a single act does not constitute abusive conduct unless it's especially severe or egregious. All right, so more examples. This is a case from 2014 from Santa Clara University. A Puerto Rican employee alleged that she was subjected to a hostile work environment. On a few occasions, a fellow co-worker of the university stated that the employee's dress looked like a poncho, and criticized her hair for being too curly, and suggested that the employee should like their office because it's next to a taqueria. Is this employee subjected to hostile work environment? And really what I'm asking is, what do you think the court said? Because this was a court case. In this case, surprisingly to me, the court said no. This was not hostile work environment. It was not severe or pervasive enough to meet the threshold, nor did it alter conditions of employment. Another example from another court case in 2006. An employee, approximately 50 years old, claimed he was subjected to a hostile work environment. The employee's manager made numerous age-related comments to the employee every time they spoke. Over time, the comments became more frequent and more degrading. The manager made comments during peer group setting and over the phone. The manager also questioned whether the employee could still get the job done. The manager's comments related to putting the employee in a nursing facility, and 2, asking the employee if he needed a cane to get to meetings. Plaintiff complained for over a year, but nothing was done. Was plaintiff subjected to hostile work environment? Or did the court think so anyway? Yes, this one, the court did say it was severe and pervasive enough. Mainly, they were focused on the frequency and the duration. So because it was happening consistently over a year-long period of time, and there had been complaints that he made that nothing was done about that, they focused more on that aspect of it to show that it was sufficiently severe and pervasive enough. Or pervasive, excuse me. Another example from the Ninth Circuit in 2003, a bank employee of Chinese descent filed a hostile work environment claim. On a few occasions, a fellow non-supervisory employee made racial jokes involving the use of Chinaman and other jokes related to communism in China. On another instance, a coworker pulled his eyes back with his fingers in an attempt to mock the appearance of Asians. Was the employee subjected to workplace harassment discrimination as according to the court? The court said no in this one because while offensive and inappropriate, it did not pollute the workplace so far as to alter the conditions of their employment. Now, I will say this case was from 2003. I think if this case was heard today, it would come out very differently. But again, it's not black letter law, like we always like to say. Very subjective based on the courtroom that you're in. Another case in 1986, even farther back, a group of Black and Hispanic correction officers were repeatedly subjected to offensive and racial epithets and demeaning ethnic quips on a daily basis by coworkers. Was this harassment? In 1986, the court said yes, because of the continuousness of it, the fact that it was on a daily basis, that was enough to show that it affected their work environment. All right, and I've said this several times, but the severe or pervasive is not black letter law. It is a spectrum that may depend on a particular judge's opinion. Let me see. Yeah. And what is considered to affect workplace as to alter the conditions of employment is not clear. And I said, best not to toe the line, act with an abundance of caution when it comes to these things. So employers must take all reasonable steps to prevent harassment, discrimination, and retaliation. Whether an employer has taken all reasonable steps depends on workforce size, budget, nature of the business, and just the individual facts of the case. Prompt response. So plaintiff may introduce evidence of the employer's tepid response to a previous harassment complaint by other employees. So if the employer kind of treats complaints like this as not very serious, and they have a history of doing that, then an employee may use that fact as evidence in their own case. Even if lower level supervisors have no authority to correct or prevent harassment by a supervisor, they may owe a duty to report it to the employer's management, particularly where the employer's sexual harassment policy requires all supervisors and managers to report incidents of sexual harassment to the appropriate management people. Oh, and I have another client that I did this, but anybody's policy, any city policy, does require employees to report any incident of harassment to their supervisor, manager, or HR. So that is part of personnel rules. Okay, so this is something that employers don't always know. There's a defense for employers it's called this lack of action by the victim. So the victim could have avoided part or most of the harm if they had taken advantage of the employer's procedures for addressing sexual harassment, commonly referred to as the avoidable consequences doctrine. The idea here is that that an employer has specific policies in place to address harassing conduct, whether that be need to go to their supervisor or HR or city manager when they feel that they have been harassed. And if an employee does not do that, fails to do that, the employer can say, well, if you came to us earlier and followed what the personnel rules say, we could have stopped it, or we could have done something about it earlier on than now. So the amount of harm to the victim could have been less if the employee had taken those actions. So it's sort of a failure to mitigate type of argument. So this is sort of the same, but from the court in 2007, the employer may be relieved of liability for a supervisor's harassment where the employee fails to utilize reasonable preventative or corrective opportunities provided by the employer. So, the employer may say, if you came to me, I would have would have relocated you. I would have put you on different shifts. I would have separated you. That kind of thing. So an example of this failure to take action. So ABC Co. provides all employees a handbook that details the company's zero tolerance policy for sexual harassment. The policy instructs employees to call ABC's HR department directly and immediately if they experience or witness any sexual harassment. John, a supervisor, walks by Jane's desk and makes a very derogatory comment. Jane is in shock and pretends not to hear. Jane does not do anything. John continues to make these comments, and after 6 months, Jane contacts HR department. Jane can bring a claim against John in ABC Co., but ABC can argue that Jane's damages should be reduced because the harassment would have stopped if Jane called HR immediately, as was prescribed in the policy book. So that's sort of an example of when that would come into play. So harassment by non-employees. So this is what I was talking about earlier to the question posed about the public. So the employer may be liable for non-employees, so employees, customers, vendors, members of the public that come in. If it's employees, so harassment done by any of these types of people, of its employees, if the employer knew or should have been aware of the harassment and failed to take appropriate corrective action. So example, employee who spoke with a heavy accent complained to employer that she was being subjected to severe racist remarks and threats by employer's customers. Employer told her to grin and bear it. Employer's failure to undertake reasonable measures to end its customers' harassment may have violated Title VII. So this is just from the case that was federal, but it would also be true for California law as well. So employer's awareness that an employee has been subjected to sexually harassing conduct at work triggers the employer's duty to take prompt corrective action that is reasonably calculated to end the harassment. The employer must take temporary steps to deal with the situation while it determines whether the complaint is justified. Simply telling the harasser to leave the employee alone is likely going to be insufficient to meet the remedial action required. All right, so what an employer's duty to take appropriate action when there's an issue between two employees. At the very least, the employer must try to eliminate contact between the two employees that is not strictly business related, must conduct an investigation into the claims, and depending on the circumstances, employees must have to continue working together while awaiting the outcome of the investigation. So in that event, the employer must take reasonable steps to expedite the investigation. So there may be instances, and this happens all the time, where you can't separate two employees that are having issues. The department, whatever department they're in, it may not be feasible to move them around. And in that case, the investigation should be expedited to the best of the employer's ability. They're also entitled to a prompt, fair, and reasonable investigation. So the most significant immediate measure an employer can take in response to a sexual harassment complaint is to launch a prompt and fair investigation to determine whether the complaint is justified. A reasonable investigation does not require a trial type proceeding, but the employer must make reasonable effort to contact the alleged victim and try to maintain confidentiality to the extent possible. This also applies to employees who may be part of the investigation process. So when a complaint comes in from an employee, the employer must investigate, which means talk to not only the employee that made the complaint, the person that's the subject of the complaint, and any other witnesses or individuals that may have information relating to the complaint. And during those conversations, it should be made clear to whoever you're interviewing that this conversation stays with them to the extent that is possible, right? There may be not complete confidentiality because the nature of this type of investigation, you may need to share information, but employees should know that they should not be discussing this investigation with any other employees, because that could cause a much bigger issue within the workplace. Policies and procedures, basic steps in the investigation. So, employers obligated to conduct an effective workplace investigation of the harassment complaint and should obtain all relevant documents, investigate all relevant avenues applicable to the allegations, and reach a reasonable and fair conclusion based on the facts. Permanent remedial steps. So, if an employer decides to separate the accuser and the accused, it may consider transferring, reassigning, or reassigning one or the other. The employer has wide discretion in choosing how to minimize contact between the two employees, but neither the federal or California law requires an employer to discharge or discipline an alleged harasser. So the employer has this obligation to investigate, to come to some sort of conclusion based on the facts that were gathered, but the law does not prescribe what they have to do about it. They don't need to terminate if they found that there was harassing behavior. They have the discretion to decide what the appropriate measure will be next. A lot of that will come down to, how you dealt with things in the past, what the morale for the rest of the workplace will be, past practice, that kind of thing. Okay. Example, when there's an issue between two employees. So employee complained after a coworker grabbed her hand and said he wanted to kiss her. She feared being raped because this coworker had made inappropriate remarks to her in the past. Employer began an immediate, thorough investigation and took various preventative measures, including separating the employees so that the harassment stopped. But the employer decided not to discipline the coworker because of insufficient evidence. So the court in this case said that the employer's good faith effort to investigate and stop the inappropriate conduct was sufficient as a matter of law. I believe in this case, the employee that complained was appealing because they felt that the discipline was not adequate. And the court said, well, we can't, the employer has the discretion to give out whatever discipline is appropriate or not appropriate, depending on what they found. Okay, so leadership. You all here have some sort of supervisory role. So it's important that policy and training be reinforced by leadership. Managers, supervisors, and employees must understand that their adherence to the standards of law and internal policies is required, and that top management should model desired behavior and provide appropriate support to managers and supervisors on the front lines. We're going to move on to a different section here: gender identity, gender expression, and sexual orientation, which are all protected bases under the FEHA. All right, so some terminology that I always like to go through because it helps with preventing this unlawful harassment if people understand what these terms mean. Gender expression. So gender expression is a person's gender-related appearance or behavior, or the perception of such appearance or behavior, whether or not stereotypically associated with the person's sex assigned at birth. This includes mannerisms, dress, or other characteristics that are perceived to be masculine or feminine. So this gender expression is how an individual shows themselves to the world. It is what is visibly, usually, you can see this expression of gender. Gender identity is a person's internal perception of their own gender identity, which may include male, female, a combination of male and female, neither male or female, or transgender. So gender is different from person's sex assigned at birth or transgender. So gender identity is internal rather than external. Gender expression is external, gender identity is internal, how they perceive themselves and what they perceive their gender to be. Transgender is a general term that refers to a person whose gender identity, so the internal, differs from the person's sex assigned at birth. A transgender person may or may not have a gender expression that is different from the social expectations of the sex assigned at birth. So transgender really has nothing to do with what's being seen in the expression. A transgender person is simply the internal identification of their gender is different than what they were assigned at birth, no matter what is being perceived by others. Transitioning is a process of some transgender people go through to begin living as the gender which they identify rather than the sex assigned to them at birth. This may include changes in name and pronoun usage, facility usage, participation in employer-sponsored activities, undergoing hormone therapy, surgeries, or medical procedures. This transitioning state, it comes up a lot in the employment context, and we'll talk about that in a second. Sexual orientation is a person's physical, romantic, or emotional attachment to another person. A person can be heterosexual, straight, commonly referred to as straight, homosexual, commonly referred to as gay or lesbian. They can be bisexual or asexual. All of these are sexual orientation rather than gender. Other terms, gender nonconforming. So a person whose gender expression, so what's being expressed outwards to the public, is different from the conventional expectations of masculinity or femininity. Not all non-conforming people, identify as transgender, and not all transgender people are gender nonconforming. So these are all very separate things. Genderqueer is a term used by some people who define their gender as falling somewhere in between or outside the categories of male and female. And cisgender refers to a person whose gender identity is consistent with the sex the person was assigned at birth. So myself, I am cisgender. I was born assigned female at birth, and I also identify as female. Okay. So why, this comes up in terms of harassment. So supervisors or coworkers refusing to use the name or gender pronoun that corresponds to the gender identity with which the employee identifies. So, example, intentionally continuing to call a female transgender employee by their male name or using pronouns he or his. Refusing to allow a transgender individual to wear the clothing associated with the gender the individual identifies with. Expressing hostility to transgender or gender nonconforming individuals because they do not look or act like the employer thinks a man or woman should act, and using slurs or derogatory terms. So these are examples of the prohibited conduct that we see. So example, Carl was born a male and has been an employee for the board for 5 years. Carl approaches manager Terry and tells him that she, Carl, identifies as a transgender woman and is beginning the process of transitioning at work. From now on, Carl would like to be called Kay, will be wearing clothing consistent with an identity as a woman, and prefers the use of female pronouns. As weeks pass, Kay's coworkers become accustomed to her new name and appearance, but some inadvertently refer to Kay as Carl and use the masculine pronoun he. Terry, however, intentionally says, "Good morning, Carl," when Kay passes by and makes comments like, "Nice dress, dude." So, are the actions of the coworkers harassment, and are the actions of Terry harassment? Kay does have a claim against Terry and the board because Terry's comments were purposeful, and because it's a supervisor, right? So supervisory, strict liability for the employer. And Kay's coworkers' occasional and accidental mistakes do not create a situation of discrimination or harassment. So in this case, because they were occasional, they're accidental, that doesn't rise to the level, but that intentional misuse would. Another term is called dead naming. So dead naming is intentionally calling a transgender person the name they used prior to transition, and it is considered harassment if it's done, intentionally and frequently. All right, let me check for questions before we do our last section here. Oh, we got some. Okay. Okay. What if the supervisor is the one harassing? Yeah, so that if a supervisor is the one harassing, you would go to HR, you would go to another supervisor that may not be your direct supervisor. Those would be your two avenues. What if the supervisor is the one harassing? Who would you report the harassment to? I just answered that. If the agency is small and it's difficult to separate the accuser and the accused, yeah, we see that all the time. It just needs to be to the best possible. If you can't separate them at all, the investigation needs to be done as quickly as possible in order to have that those relations stop as quickly as possible, or to get to the bottom of whatever's going on. We see that a lot with the small agencies, but it's really just the employer's good faith effort to do something. And then I have, can failure to use one's preferred pronoun be considered harassment? I think I just kind of covered that, but yes, if it's done, if it can be shown to be done over and over again and intentionally, that could be considered harassment. But if it's unintentional and happens every once in a while, and the transition is sometimes hard for people to comprehend very quickly, and so if it's done accidentally, no, probably not. If it's done as a statement of, I don't agree with this, and therefore I will continue to use someone's non-preferred pronoun, then yes, that would be harassment. All right. So abusive conduct and bullying. Workplace bullying. You hear this a lot, right? You're bullying me. Technically, not illegal. There is not currently a basis for a lawsuit specifically for bullying. However, it may violate employer's policy. So there could be a policy violation, but is there a civil claim for bullying? No. But, this type of abusive conduct has a negative effect on the victim in the workplace. And, bullying goes beyond what we think of bullying. If it's based on a protected class, then it could rise to the level of illegality, because now you're discriminating based on a protected class rather than bullying someone for something that is not a protected class. And we'll go through a kind of example of that. California law defines abusive conduct as conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interest. All right, so examples of bullying in the workplace: yelling at coworkers, making threats, spreading false information or rumors, attempts to destroy self-esteem or self-confidence of others, and behavior meant to undermine or patronize, humiliate, intimidate, or demean. So as supervisors, let's back up. As supervisors, you want to stop bullying from happening in the workplace. And that's why it's against policy. That's why, employers make sure that employees come to them with any of these issues. But what I mean by not illegal is that it is not a basis necessarily for discrimination or harassment to constitute hostile work environment. Now, remember, we talked about those 17 protected classes. So unless the bullying is specifically correlated to one of those 17 classes, it's not going to be in violation of the FEHA in California. So I hope that makes sense. And I'm going to give an example that shows that. All right. So every employee deserves to be treated with respect. But this does not mean that supervisors and employees cannot be firm or critical with each other, but they should communicate in a constructive and professional manner. All right. So, like I said, bullying is separate from harassment. Harassment requires conduct to be because of the target's protected characteristic. So, examples of bullying include repeated infliction of verbal abuse. So, demeaning comments about person's appearance, patronizing titles or nicknames. Now, person's appearance, let's go back to that have nothing to do with their gender or their race, their religion. So, something like, oh, you have so much dandruff in your hair. That's not related to any of the protected classes, but it's still demeaning and it's still about someone's personal appearance. Patronizing titles or nicknames, unwelcome teasing, setting someone up to fail, derogatory remarks, insults, epithets that aren't related to one of the 17 protected classes. But this could be, this abusive conduct. But a single act should not constitute abusive conduct unless it's especially severe or egregious. So let's look at an example and it may become a little clearer. So Jason is a new employee at Megastore. Jason is having difficulty learning the office protocols. Jason asks his supervisor, Mary, for help. In a loud, sarcastic voice, audible throughout the workplace area, Mary yells, I've shown you how to do this simple, easy, basic task over and over, and you still can't get it, you dummy. I won't show you again. Can Jason sue Mary? Can Megastore be held liable for Mary's actions? If not, what are Jason's remedies? So right? So Jason can't sue Mary for abusive conduct because it doesn't fall within the framework of the FEHA. So let's look back at what she said. She said, I've had to show you this simple thing over and over. You can't get it, you dummy. So a person's intellectual ability is not a protected class. That does not fall within any of the 17 areas of protected class. So it does not fall into the framework of FEHA. But Mary's actions could constitute abusive workplace conduct under policy, and she can be disciplined for the violation of the behavior policies, but she would not be liable for harassment under FEHA. So that's an example of one that seems like it should be, but it is not. Okay, so same facts as previous example, but Mary also states that Jason states, quote, Jason are all Irish mutts as stupid as you. What is it about that thick potato head of yours that you can't understand the most simple and basic instructions? Now things have shifted, right? Mary would likely be found personally liable for harassment based upon both race, Irish. And the employer would be strictly liable for Mary's conduct as a supervisor. So because she made a comment about Irish mutts, derogatory based on race, then that does fall into the framework of FEHA. So as a supervisor, you all have the responsibility to speak up, to comply with an investigation, and to not retaliate against any accuser. If you do or say something that crosses the line, this is sort of how you should handle it. You thank them for telling you, apologize for making them uncomfortable, state the behavior will stop, then do not continue the behavior, do not retaliate, and document the conversation. I've spoken to many of you looking at the list of participants, and my answer all the time is make sure there's a documentation of the situation, whatever the situation is. A paper trail is good for everybody. And so making sure everything is documented as to the best ability of everyone is always going to help. So documentation of a complaint, documentation of what the investigation consisted of, what the result of the investigation was, how that was communicated to everyone. All of that should be documented. All right. A little bit more on what to do when someone comes to you with a harassment complaint. You should give the complaint top priority and take it seriously. Review your workplace anti-sexual harassment policy or anti-harassment policy in general. If determined to be serious enough, conduct a formal investigation. And just, I think this is the last slide. So some steps for a formal investigation. Conduct a thorough interview with the complaining party, preferably in person. Give the accused person a chance to tell their side of the story. Relevant witnesses should be interviewed and relevant documents reviewed. Do any other work that's necessary to get all the facts. Perhaps visit the work site or view videotapes. Reach a reasonable conclusion based on the information collected, and then complete a written report and communicate the findings in a confidential manner to the parties involved. That's sort of the basic framework of an investigation. And I think, so some additional resources, just the DFEH website and the Fair Equal Employment Opportunity Commission website. That will, I believe, conclude this portion of the training.